Lawyers, has any client ever made you go, how the F am I supposed to defend you? And if so, how did it go? I'm a criminal defense guy, so I've had plenty. Most infuriating one was a guy that got busted for selling rocks to a confidential informant. The CI was wired for sound and video, so the whole transaction is crystal clear. Plus, the cops ID'd his car as the one that drove up the scene, and he was stopped a couple hours later with the buy money in his possession. Serial numbers were recorded. He had 3 prior convictions for cocaine sales. The prosecutor offered him 5, which was the mandatory minimum. He absolutely declined to even consider a plea, insisted on a jury trial, insisted on taking the stand, and telling a ridiculous story about how it wasn't him in the video. There wasn't any doubt. I felt like Lionel Hutz trying to string together a closing argument with a straight face. He got 20 years. Next story. My friend's mom was a defense lawyer for a hospital. Her job was to represent doctors accused of malpractice or anything relating to doctor-patient interaction. I forget all the details, but she had one case where a female patient had accused a male doctor of SA. The claim was that the doctor groped the patient several times during a procedure. Allegedly, the doctor had been coached to say that during a routine procedure. It's possible that he had inadvertently brushed up against the patient's chest, and that if it happened, it was an unintentional consequence of following standard procedures. So they get to the deposition, and I guess the first question the doctor gets is something along the lines of, "Walk me through what happened." And the doctor says, "I don't know what you want me to say, man. I'm a tick guy. Always have been." They settled. Next story. My client gave a textbook perfect confession to a robbery the police had no leads on. He had walked into the police station and told the front desk that he thought the cops were looking for him. He then volunteered that he and a friend robbed a gas station last week. Then, after police arrested him and warned him, right to silence, etc., and after he spoke at length with counsel, not me, he repeated his confession in an audio-video statement. He wasn't forced or coerced. He hadn't been detained for an unreasonable time in cells first. They hadn't even interrogated him, but as a result of his confession, they were able to get a DNA warrant and matched him to blood swabbed at the scene. And the best part? The police had no idea beforehand that it was him. My client and his friend had covered part of their faces. The surveillance video was horrible quality, and they had bear sprayed the store clerk, a 16-year-old kid, immediately upon entering, so the kid hadn't been able to provide the police with any description beyond 2 males. And since he had no criminal record, he wasn't in the DNA database from previous crimes. He just heard a rumor that police were investigating and assumed they knew it was him. I had to laugh when I got the police report and read all of this. I then focused on securing him a fair plea deal because he had no chance at an acquittal. Next story. I had a family client whose ex wasn't letting him see his kid, so we were in court with him explaining how important parenting was to him, how much he loved being a father, etc. After 45 minutes of this, the mother says, "I don't know why he's saying this. He abandoned his other kids." Cue me, who has never heard him mention having other kids. Turned out, 100% abandoned them, has had no contact for years, never made any efforts. Please give your lawyers important information, especially if another party involved knows your secrets. Yeah, honestly, what do you stand to gain by withholding information from your own lawyer that you're hiring to win you a case? Why would you hold anything back? It's literally their job to, fact or not, twist a story or a narrative in your favor. Come on, dude. Next story. I had to try to defend a man who walked into a convenience store with a knife demanding money. He wore no mask, just his casual clothes, and walked through every aisle before he robbed it, being spotted by every security camera in the store. After the robbery, he ran back to the hotel he was staying at, also carrying an open backpack full of money, being seen by the hotel security cameras in the process. He then went into his room, threw the bag on the floor, and hid under a bed until the police arrived. I spent a long night thinking about it before passing the case to somebody else, because I have no idea how to defend someone who has so much evidence against them. Next story. I went to a meeting where an older couple, in their 80s, sent their life savings to a Nigerian prince in 2009, who was going to triple their money and send it back. They sent money in 2 installments. The grand total was around $40K, and it was obviously stolen. They wanted to know every option they had to get it back, and the answer was simple. None. There's nothing you can do to get your money back. I've never seen 2 people so mentally broken. They were retired and no longer had access to money in any way. I excused myself from the meeting by faking a call and started crying in the bathroom. I couldn't handle it. Next story. I'm a paralegal, although I'm in IT now, but previously I was in other areas. Well, in court, the case before ours at the time was for theft and was going on much longer than it should have. Defense lawyer calls for a motion to dismiss, claiming lack of evidence. Judge says he'll entertain said motion after lunch. Hits gavel, says court will reconvene at 1 p.m. Court dismissed. Defendant stands up and says real loudly, "Told you I could get away with stealing that crap." He thought his case had been dismissed. Next story. This isn't my story, but is just too perfect to not mention when one of these threads comes up. So we're at a bail hearing for the client. An older guy in his 70s accused of essaying his granddaughter who's in her teens. We're just wrapping up, have made all our arguments that the client is an upstanding member of the local immigrant community, no priors, etc., and the judge has granted bail with a reasonable bond. All done, right? No, the client insists he wants to say a few things, so he stands up and gives his bit, that he hadn't mentioned to his lawyer at all, about how he doesn't get why there's all this fuss, he didn't even penetrate her with his chicken after all, she was asking for it with that short skirt. At this point, the judge tries to interrupt this by suggesting that maybe his comment would be better suited for sentencing, but the old guy isn't done digging. He just has to tell everyone how he really doesn't know why people are wasting so much time over all this, as he's going to fly back to his home country in a couple days anyway. So yeah, apparently that one didn't go well. Next story. All I can think of is how I saw this guy on the TV, Dutch, who was accused of possession of firearms. He didn't have an attorney as he didn't want one. His reasons? He didn't need an attorney because what he was doing was actually legal. The judge asked him if he was sure. He said he was. Then he was convicted. That was pretty much it. Next story. The client who said they didn't speak English, so we had to get an interpreter. When asked questions, the client kept answering in English, and the interpreter would have to stop and ask again and then answer in the language. Long, confusing deposition, to say the least. The client spoke better English than anything. Next story. As a PD, pretty much every single client that wants to take their case to trial and is completely delusional about how strong their defense is. I don't know if it's drugs, narcissism, mental illness, but so many just are in complete denial even when you show them the whole thing on video. They don't understand that a witness saying what they saw happened is evidence despite telling me they're being railroaded with no evidence. Especially with strict liability type offenses like driving under suspension, and don't get that, I was only driving 3 miles to do X and those cops just wait outside my trailer park waiting for me because they know my car isn't a defense. Next story. In AL, a lot of defense lawyers will defend some monsters who absolutely did the crime. In that case, their job isn't about proving the person innocent, it's more about making sure they have a fair trial with everything done properly. If things get done wrong, the person can walk free because they didn't have a proper trial and declare them guilty. Next story. Oftentimes during discovery, you'll get requests for admission, which are a set of yes or no questions designed to get basic, non-contested info, like whether our client was the one driving the car at the time. Often, plaintiffs' lawyers will throw in a gotcha question that pretty much states, admit the whole thing is your fault and you owe plaintiffs a bunch of money. 99.9% of the time, we'll deny them because it would sink our whole case. But I had one idiot defendant who insisted on admitting that one. We lost. Next story. There was quite a famous case in my country that I heard about today. I'm a law student, and it was an example. We skimmed over it, though. The details may be wrong. It wasn't the victim that made the lawyer go, "How the F?" but the prosecutor. There was once a company who had an illegal business of selling radioactive waste, or something like that. It doesn't matter for the sake of the story, just know it was illegal. Years of criminal persecution in vain, as the accused refused to say anything. They got nothing out of them, not a single word, so they decided to get them to a parliamentary investigation court. Back in the days, there was a special oath to be sworn if you had to appear for a parliamentary investigation court. The oath stated that you had to answer any question truthfully. The accused had 2 options. 1, tell the truth, go to jail. 2, tell a lie, commit perjury, go to jail. What did they do? They told the truth, but like the whole truth. Every single detail. The prosecutor did not need to ask any questions. The accused told them everything. The investigation court was very pleased to hear them turn themselves. Look at how efficient we are. What the criminal court couldn't achieve in years, we could in mere minutes. We're the best, guys. Then the lawyer stood up. According to the Bupo Treaty of the EU, I don't know if it has another name in English, that this country signed, the accused cannot accuse themselves and be persecuted for that. My clients just accuse themselves, so you cannot condemn them. The investigation court had all the information at their fingertips, but it was useless. The accused walked out as free men, the lawyer became known in my whole country, and they changed the oath. From now on, you're allowed to refuse to give answers to questions in a parliamentary investigation court. End of story. Again, I'm not sure about the details. We briefly skimmed over it. It's a fun story to show that a parliamentary and criminal investigation court are not the same and had different rules back in the day. I did not focus on the details of the story, only the gist of the message, aka you can be silent. A few years ago, you couldn't. So don't shoot me if it's wrong. Next story. I've posted this here before. I'm not a lawyer. I read about this. Two guys were being tried for robbing a gas station. A customer who saw the robbery was now on the witness stand. The prosecutor asked him to describe what he saw. The witness said that he saw two guys robbing the store, and while running out, one of them bumped into him. Then the prosecutor turned towards the two defendants and asked, "Are those two men in the courtroom today?" At which point, the two idiots raised their hands. I'm sure the defense lawyer thought, how the F am I supposed to defend you now? Yeah, we're seeing a lot of self-condemnation in these stories so far. Yeah, less is more, right? Unless you have to say something, stay silent, keep your hand down, sit down. You're just making things so much harder for yourself. Next story. My lawyer father once had a client who was suing the federal government because he claimed his parents had sold him to the feds for testing as a child. The client claimed they had him constantly under surveillance. When asked how he knew who was watching him, the client said the government used minivans and station wagons in the late 80s, and they were always parked outside his residence. The client lived in a motel in a resort town. Next story. Sometimes, child predators and fraudsters are often in denial. They'll refuse to enter a plea of guilty even if the evidence is overwhelming, and even though a plea would substantially reduce their sentence. In those cases, you're just put in the position of explaining to the client their low prospects of success and putting the prosecution case to the test. In a guilty plea, you have the opportunity to explain some mitigating details in the defendant's favor. Very occasionally, the defendant is a miserable, unrepentant arsehole who had every advantage in life and still effed it up. In those rare cases, I'm forced to brush over the defendant's antecedents and focus on making sure the sentence is in range. Teenage boys can be very difficult to work with because they're focused on impressing you, so getting those mitigating details is like extracting teeth. Note, if you're a teenage boy, this doesn't impress us. The actual hardened criminals we deal with have danced the dance many times, and they're forthcoming with details like their difficult upbringing, the courses they've enrolled in, and so forth. Fortunately, in the case of teenage boys, their mother often comes with them, so I can ask her for humanizing details like their favorite subject at school, their future plans, how they fell into a bad crowd, and so forth. Next story. Not that phrase. On 2 different occasions in the last 3 years, I've declined representation, and in each case it was someone who had been sued, was served with the papers, had completely ignored them, was defaulted, received and ignored the request that the court entered a judgment based on default, and then ignored subpoenas and other directives relating to creditors' exams. Then it finally occurs to them that they should consult with a lawyer. Far too late to do anything. My question, not spoken out loud, how in the world do you get through life? Next story. I always heard it wasn't about defending the client, but about defending against improper state behavior. The police and prosecutors need to be held just as accountable for how they conduct investigations, evidence, interviews, etc. No one likes it when a child essayer gets off on a technicality, but defense makes sure, to the best of their ability, that the state can't overrun procedure. Next story. Not a lawyer and not the one asking a lawyer, yet I got a story for that one. My ex's landlord sold the apartment and the new one threw my ex out, following all the rules like in total detail, and even offered him money if he moved out before the deadline and a new apartment to move in the next day pretty much. Those 2 things are not required by law, and it was a nice helping gesture of the new landlord. My ex's mother talked him into getting a lawyer and trying to sue the new landlord. I tried telling him that this is BS, he won't get anywhere with it. Needless to say, he seemingly always thought I was too stupid. He followed his mother's advice and talked to a lawyer. As far as I know, the lawyer nearly laughed at him, telling he can sue the new landlord, but he'll lose and most likely even lose the 2 offers. My ex still wanted to sue him. Didn't work out though. Pretty sure the lawyer didn't sue him as this was completely useless, but there's a chance that the lawyer wrote some notes to the new landlord. He also didn't get the offered apartment in the end. Next story. I had a client come in and spin me this yarn about how he owed all these child support arrears and the payments are killing him, and could I file a petition to have the payment reduced? He spins this tale of his spouse alienating the children, and that's why he never saw them. I filed the petition, and the clerk called me aside one day and said I might want to review his actual divorce file, not just his child support file. That was a wild ride. Orders of protection due to stalking, losing his visitation due to meth use, not making a single child support payment in 14 years. I do the best I can until he admits on the stand that he smokes a carton a week and drinks over a liter a day. So that's over $200 a week in cigarettes and liquor, and a little weed sometimes. It did not go well. I was a baby attorney at the time, and I could tell the judge wanted to tear me a new one for even filing this, but I was so beaten down by the end of the hearing that it would have been child abuse at that point. Yeah, I don't even know if the best lawyer in the world could have gotten this guy out of the jam that he worked himself into, and also $200 a week on cigarettes and liquor. My goodness, that's awful. Next story. Late night closing on a multi-million-dollar deal. This was about 120 billable hours into my week, worst week of my career. Client came into our office to sign the papers and finish the negotiation. We finally got the deal signed up around 2 in the morning, with the banker set to initiate wires when the businesses opened. As the client was leaving, he took a decorative vase from the front desk of the firm on his way to the elevators. I was finishing up documents and didn't see it happen. Earlier in the week, he'd been talking about taking some of our office chairs because they were nice and he was paying the bills anyway. Long story short, client was a kleptomaniac, and it cost the partner on the deal about $20,000 out of his own pocket because his client was stealing random items from our office. Next story. A group of 3 young boys in my city drowned their neighbor's cat and recorded themselves doing it with their phones. The videos were copied by their friends, who would inevitably be shown to the jury in court. It was a case of evidence speaking for itself. All I could really do is argue for lighter punishment using their age as defense and the disastrous effect that group mentality can have on young people. Yeah, if you're going to commit illegal acts, you probably don't want to film yourselves doing so and then blast it on the internet. Just an idea. You don't have to listen. Next story. Did an apprenticeship at a law firm but never pulled the trigger on going to law school. We had some very shady characters come through, some of whom were even clients. But in all seriousness, among the clients, I remember a family law client dying of cancer, trying to make sure his ex-wife got 0 of his assets, shot the bird at his ex during a hearing after we had just got done making a character argument on his behalf. Literally seconds after our attorney had shared with the judge his client volunteered for his church, coached Little League when he was younger, and was a war hero. He gave a big fat middle finger to his ex-wife in plain sight of the judge and everything. However, the wife was just as despicable, and the judge ruled in client's favor. Another divorcee, in California. When a restraining order is filed, the party whom it was filed against must submit all weapons he owns to the county sheriff for 30 days. This is usually a formality and a precaution most people don't have a problem with. When our client doesn't go to the sheriff to hand over the 30-plus guns he was registered as being the owner of, the sheriff came to him. He claimed he sold them privately in Arizona, where a seller isn't required to disclose that information, and it's legal to bring in guns from out of state. Search didn't yield any weapons, but, being the genius that he was, he went gloating around the small town that they lived in, and that all of his guns were in a storage unit registered under a friend's name. Of course, word got around, and the sheriff came knocking again, asking him about the storage unit. Somehow, he convinced the sheriff it was just a rumor, but then he shows up at the office, flabbergasted about his rights, supposedly being compromised. After a loud conversation with the attorney, he pulled me aside, just some apprentice not knowing what's going on, and offered to pay me to help move his guns. He was elderly and disabled, and they were in heavy lockboxes, to a friend's house. Of course I helped when I was on my lunch break. Disclaimer, I had no idea about the preceding drama and didn't realize what I did could potentially get the lawyer I worked under disbarred, or if nothing else, ordered off the case by a judge. I got yelled at pretty good for that. I believe the case was settled amicably, and client didn't end up violating any other terms of the restraining order as far as I know. Next story. My aunt is a retired lawyer. She once had to defend a guy who was in the possession of weed and other drugs. He swore he didn't have any, but he obviously did because on the days leading up to the trial, he looked and smelled more crappier than the day before. Finally, on the day of his trial, he showed up with a cigarette in his mouth and a can of lager. He was high as frick, and there was obviously some drugs in his system. My aunt told me, as she was retelling this story, as soon as he walked in, I knew it was about time for me to frickin' retire. P.S. He lost the case, even though my aunt tried to get him a lower sentence. I think he's serving like 20 years or something now, lol. Next story. When I was working as a bailiff, we had a bond hearing for a domestic violence case. Here's the exchange. Judge goes, "Sir, you've been charged with assault on a female, resist public officer, and felony assault by strangulation. The maximum possible punishment is 120 months in the Department of Corrections. At this time, you have the right to remain silent, and anything you say can be used against you in court. You have a right to an attorney if you cannot afford counsel. I'll appoint one to represent you." Suspect says, "What are the charges?" "Assault on a female, resist public officer, and felony assault by strangulation." "How the F am I getting charged with assault by strangulation? All I did was choke her with my hands." "Sir, I will remind you that you have the right to remain silent." "A felony for choking her with my hands?" "Yes, sir. Would you like me to appoint you an attorney?" "F you!" "Sir, I'll appoint you an attorney in this matter. You can choose to hire an attorney at a later time. I'll set your bond at $10,000 secured." $10,000? F you! I better not see you when I get out. And then the judge goes to the clerk of court. "Madam Clerk, I'm amending the bond amount." "That's what I thought." "The new bond amount is $50,000 secured." "F you! Suck my male chicken, you piece of crap." "Madam Clerk, I'm amending the bond amount once more to $100,000 secured." The suspect then had to be forcefully removed from the courtroom by bailiffs and jail staff. Months later, he went to jury trial, against his attorney's advice, and all the witnesses from the above exchanges were summoned to testify to his statements that he made. Needless to say, he lost. But I gotta hand it to the defense attorney. He really did try, even though the case was unwinnable. Remember, folks, listen to your attorney. They probably know what they're talking about. Next story. Not a lawyer, but a friend of one. I have his permission here to say this, so don't come at me. He's a family lawyer, works with a lot of effed up families. Once had a client whose wife wanted a divorce and for him to be arrested on domestic abuse charges. He ran from the police to his mom's house. From there, he sent multiple threat letters to his ex-wife and asked her for money. His mom let him stay for a bit, but he also left her place soon after. They actually caught him outside of his ex-wife's house. He had wanted posters out and everything. His wife won the case. Next story. I work in the legal system. Not a lawyer. Sorry, but this situation is pretty good not to share. A defendant was arrested for breaking and entering, went into a neighbor's home after being told not to and sat down, acting like they owned the place and started smoking a cigarette. If I remember the charging court paperwork correctly. When the police came and proceeded with an arrest, the defendant straight up, with no prompting, said basically, "Oh, and I killed my other neighbor." They didn't have many leads, so this pretty much gave them what they needed. I don't know how the defendant's attorney is going to be able to defend with that confession. Next story. I had plenty of these when I was a public defender. Most finally cave right before trial, but some doubled down on the stupid. They'd curse at me and say I was a fake lawyer because I wouldn't file a stupid motion they wanted. I had a guy butt-essay his girlfriend and beat her within an inch of her life. She was sent to the hospital where the cop showed up, got all the gruesome pictures, and a DNA sample of the semen he left in her. Dipcrap rejects a deal I got him to plea to one essay count. The battery counts and other essay count would be dismissed. During trial, my guy vomited during his ex-girlfriend's testimony. I managed to expose some minor inconsistencies in her story. Dipcrap insists on testifying despite his recent impeachable felonies. In my state, it's the defendant's decision. He gets caught in a lie. During closing, the prosecutor cracked him like an egg. He cried like a female dog. 5 hours later, got a split verdict from the jury. Not guilty on one of the essay counts, saving him 6-30. My peers were amazed. Of course he wasn't happy. This wasn't his first violent crime. Hope his dumbass rots. He deserves it. I hope his ex can live a normal life with that psycho behind bars. Next story. I had a client once, was self-represented in a divorce case prior to retaining me. Comes to me the day before a case conference. I ask what he's filed with the court. Slides an envelope across the table. I open it. It's a multitude of pictures of his overweight wife, spread eagle, camera 3 feet away. showing her private parts. Yes, the judge saw, and no, he wasn't pleased. Apparently, X had caught wife sending these pictures to men on the internet. This is a short story, but absolutely sick. Like, what is wrong with people? How many wrong turns in life do you have to take to end up in that situation? Awful. Next story. I'm not an attorney, but my wife is. She doesn't do anything criminal law related either. She mostly does property law. She has a low percentage of people that call her to ask to sue people for really stupid questions, and she has to explain to them if there are no damages. We have nothing to sue for. Her consultations are always free, but she chooses the cases to work. So this type of thing happens, but it's up to the lawyer to take the case. With that said, she had an associate, not business related, but under the same roof, who would say yes to every case, but required a $5,000 retainer. He was a terrible attorney, but well marketed. He has pretty bad results, but always gets paid. Next story. Oh, definitely. At that point, you either hope the opposing lawyer's an idiot and won't do the bare minimum, or maybe they'll mess up a procedure that will help you. Both have happened before. Or, what's more likely, you try to convince your client to cut their losses and settle. It doesn't always work, to be honest. I used to be more annoyed by clients like that, until I realized that if they were smarter, I'd have less work. Next story. Where I practice, it's a crime for people convicted of certain crimes to possess a firearm within a certain period of their conviction. I had a client charged with a violation of this statute. His explanation to me was he had the gun to keep his nephew from shooting his girlfriend. A noble reason, to be sure, but not a legal defense. A review of the police report showed that the cops had probable cause to detain him and pat him down, and had discovered the gun in his pocket. There were no prints or DNA testing done on the gun. There was no testing done to make sure the gun would fire if the trigger was pulled. The nephew was not able to be located for the trial. The state offered my client a plea deal. They would reduce the charge to an attempt, and the judge agreed to sentence him to 7 years. The minimum for an attempt. My client insisted on a trial. My client insisted on testifying in his own defense. I tried to coax the nephew's story out of him on direct. On cross, he admitted he had previously been convicted, in the very same courtroom we were in, and that the pistol admitted into evidence was the same one taken out of his pocket by police. He was, of course, convicted. He was sentenced to 11 years. Because of some technical issues with his sentencing, he had to be resentenced a few years later, and at one of those hearings, he told me he wished he had taken the deal. Next story. Civil law. The man claimed that his ex had not paid an amount that was agreed in court when they legally separated. So he sued her to get that money 2 years after the breakup. In her defense, the woman says that there's no debt because she already paid it a month after the agreement. Proof that she had made the deposits attached. She also sued him because of that. So, turns out he was lying. She did pay everything in the right time. We asked the judge to set up a meeting so he could do a new agreement and maybe end the both suits with one move. After a harsh approach, he brought us the bank receipt of that year, with the proof that he received the pay, and basically spilled out that she supposedly cheated on him and accused her of having cash out the money that herself had deposited in the bank at the same time of the separation without his knowledge. A considerable amount, and not be noted by a guy who didn't make a lot of money, as she also allegedly had access to his bank's passwords. In other words, he was seeking revenge by law. I don't know how it ended, since I don't work there anymore, but it didn't look good. TLDR, man makes a lawyer sue his ex for some debt, but he was lying and she got proof. Next story. Not me, but a story my old teacher told me. He was a lawyer in the early 80s, and he was defending a woman who claimed she was SA'd by her ex-boyfriend. Her story was that while they were dating, he had come to her apartment, forced her down, and SA'd her. When asked what day that was, her boyfriend provided evidence he was out of town for the entire week her event happened. She then proceeded to change the date, and she gave an exact time, to which he then provided evidence that he was at work that day, during the time she provided. She then proceeded to throw up her hands and say, "How else am I supposed to convince you that he SA'd me?" My teacher apparently gave up that point and just asked her to shut up before she got herself in even more trouble. The case was dropped. The boyfriend never made any claims against her. Well, he's a better man than I. I don't know if I could just let this go and walk away after she's literally making up all of these lies just to try to get you arrested for SA. That's ugh. Next story. I had a client come in for DWI. She was about 40 and her mother came with her. She went into this story about her medications and how she wasn't drinking, and she was framed by her ex, that was the supervising sergeant of the officer who arrested her. There was some difficulty getting the video from the prosecutors, but eventually we got it. Up to that point, she had insisted on a trial. I took her, without her mom, to watch the video. She was wasted, couldn't walk straight, clearly intoxicated. Admitted on the video she drank half a bottle of vodka before driving. I asked her if she thought we could convince the jury she wasn't intoxicated. She then agreed to take the reduction I had worked out for her. Thankfully, the prosecutor hadn't watched the video yet. Her mother was furious with me. I told her it was the client's decision, not mine or the mom's. Client eventually reached out to thank me for not showing the video to her mom. Weird relationship. Next story. I haven't read the comments on this post, so I don't know if this has been said already, but I've dated a couple of now attorneys. They were in law school at the time we dated, and it's my understanding that at a point where you know that your client is without a shred of doubt guilty, it becomes a matter of getting your client the best possible deal with regards to a sentence. Of course, sometimes that isn't even an option, but they're still entitled to legal counsel in any event, just to make certain that everyone involved in the potential or probable conviction dotted their I's and crossed their T's. Minnie is the criminal that's gotten away with literal murder on a technicality and or shoddy police work. Cough, Casey Anthony, cough. Even though I typed that out loud, I watched a documentary about that case, and while I obviously don't agree with the not guilty verdict that the jury returned, it was shoddy police work that gave the case all it needed. Reasonable doubt. Be safe out there, everyone.